I estimated my pace. I type using one finger. Like Professor Wajakoya. Professor Wajakoya. Second, it was admitted that the public safety dictates that the first accused is denied bail or bond. Third, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he would fail. I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the prominent to strike a balance between the rights of the accused and those of the victims, in line of that principle of a delicate balance between the competing rights. How that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. Reports at page 39, it was held that in opposing applications for bond, that is the Court of Appeals saying, or bail, on grounds set out herein above, it is not in terms of public safety and severity of the offense and persuasive. In any event, gathering from the foregoing principles, the applicant concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the local. Further, this is a question capable of determination in another forum separately. Disposition. Consequently, in to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B, shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing 2 suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C, upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Roman 1, that the first accused undertakes not to interfere with witnesses and or evidence. Roman 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3, that the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4, that in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5, that the first accused undertakes to appear before court as and when required. Roman 6, that the first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention or hearing unless exempted from attending court physically. Roman 7, that in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8, that in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9, is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision which can be read by yourselves. Roman 10, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state, except with the express permission of the court. And Roman 12, that the first accused is warned this connection except in the court proceedings to ensue. The first accused is warned against discussing in public. D, that the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be deemed to have completed indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. The prosecution is at liberty to serialize them in volumes. D, the prosecution is directed to serve the said list of witnesses and bound documents upon the accused or with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F, at 9:00 a.m.
This for 2 months, the governor is not able to work. That goes against the Constitution, Your Honor, and against the people of this country.
Your Honor, the role of the prosecutor is simply to institute and undertake note. What you have is, the prosecutor is simply to institute and undertake note. What you have is the truthfulness of Mr. Macharia, which is not flat jurisdiction, but even if you had
May 2025, relating to the question of visiting the office by ESCC. The request is granted. Court directs that each time ESCC wishes to visit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any order issued restricting a right traditionally is construed strictly in the narrow sense it's crafted. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from working. The denial to access the office means that the physical office, and that is why it's specified the headquarters of Trans Nzoia County for the period of 60 days. That is what it means. So that office, if ESCC after 60 days, they're like, we are done, then if there are issues, the court will be approached. If there are no issues, of course, that will be the end of that restriction. I did not wish to give a permanent restriction as yet. However, if other courts in the future think that there is need for a permanent restriction, that I'm not in control. What other issue? I think I've clarified that issue enough. For potential arrest, unfortunately, all counsel seated here understand my, my limitations. Before I understand, they understand. So I think the High Court is just across the road. We can approach it for if there is a problem, but I want to believe we are not acting that way. That is, I'm just expressing a belief. I don't think we want to act that way. The less I say about that, the better. Allow me to stop there. Thank you, thank you. And a minute, the copies, I've seen a few typos. Copies will be available in a a matter of about 8 minutes, copies of the ruling. So wait for the copies in 8 minutes.